Number 56, the matter of Wegmans Food Markets versus the Tax Appeals Tribunal. Good afternoon, counsel.
Good afternoon, and may it please the court. Frederick Brody for the commissioner. I'll reserve 3 minutes for rebuttal.
Great. Mr. Runt, does it matter that the contracted for reports are prepared and presented in a very tailored and specific way to the client?
It does not, Your Honor. Retail Data's processing of the information did not make its sales non-taxable. Collecting and processing information are, in fact, taxable services. 1105C1 taxes the furnishing of information. Furnishing includes the services of collecting, compiling, or analyzing information. And that's an inclusive definition, it's not exclusive. So the fact that Retail Data collected prices, checked them for accuracy, and compiled them into Wegmans format actually makes its services taxable.
So, counsel, what's your test for meeting the exclusion? What would the test be?
Well, information that's individual in nature relates...
What does that mean? I mean, that's kind of the same way of saying the test, right? So the language of the statute. So how is a court looking at any of those things going to tell if this is personal or individual in nature? What's the test we apply?
Well, I think stepping back for a moment, if the legislature had wanted to exclude supermarket pricing data from sales tax...
No, but let's get away from even from the facts of this case. But I'm having a hard time understanding, as a court, what's the test I'm going to apply? I mean, I know there are examples given. We can point to this department doing this in this case and this department doing in that case, but I have a hard time figuring out what's your rule.
Well, let's start where the parties agree. Information that's personal in nature relates to a particular person and his or her characteristics. The parties agree on that in their briefs. So we argue that information that's individual in nature relates to a particular thing or entity. It's the analog of personal information for non-persons.
Which entity or which thing? So is it the person asking you for the information, or is it the person you're collecting information on, or the thing you're collecting information on?
It's the subject matter of the information. Because remember, nature applies to information. So the information has to be personal or individual in nature. It shouldn't matter who buys the information.
So is the distinction the collating of data or the creation of data?
It's neither. It's the data itself. What is the subject matter of the data?
So every factual point, every specific item is in the public realm, and that would mean every political polling data that's taken place, each individual would not be included under this. That would not be a personal or individual in nature if you were conducting a political poll. Is that right?
Well, right, because those are aggregate statistics. And like, for instance, macroeconomic statistics, they don't focus on a particular person. And tax department regs illustrate this. The example for individual information is an automobile damage appraisal. Mm-hmm. You're talking about a particular car that suffers unique damage. And the commissioner's view of individual complies with the canons of statutory construction. You're supposed to construe words in a way that's similar to adjacent words.
So it seems like in that example, and I know the example that's often given is the private investigator who looks at these candidates for insurance or whatever it may be. So is it that the person collecting the data has to add something to the equation? An assessment of damage, you're looking at what's anyone can see, but you're taking your own expertise and saying, okay, this damage is X amount, or you're looking at different factors and you're coming to a conclusion about the risk of this person for insurance purposes. Is it that type of a test?
Well, certainly, when someone renders professional services like legal advice or risk analysis on a particular person or a particular business to acquire, that is focusing on the person that is the subject matter of the data. And sometimes when you're doing consulting, and the Westwood case...
well, what if there are 3 potential targets to a merger? Does that then transform it to not individual?
I think if you're dealing with each target separately and not aggregating information.
Single report. You're looking at a single report and saying, here's 5 different potential acquisition targets. We've evaluated, ranked them on a bunch of dimensions, and here's what we recommend.
Well, that would not be a
That's not
focus on the
individual.
aggregate. That would be a focus on the individual for each of the 5 targets.
Let me ask you
don't
something.
have that.
Let me ask you something different. Is there anything you're aware of that would help us figure out what the legislature meant by these words? And so I've looked at not every, but a lot of the cases cited, and I can't find any one of them that goes back and says, here's something in the legislative history that helps us decide what these words mean. Do you know of anything?
Yes, I do.
Okay.
The exclusion originated in a New York City tax regulation, not the tax code, but a regulation that was adopted in 1956. It was Article 98 of the New York City Regs on Sales and Use Taxes, adopted January 5th of 1956. And that regulation gave 2 examples of information that was personal or individual in nature. First, an investment counselor's report recommending a portfolio of securities based on the investment needs of a particular client. And second, the investigative report of a private detective. Again, you're looking at a focus on the individual level, not the macro level. The investment counselor is looking at their particular client and making a recommendation that focuses on that particular client.
So does it matter if the person who buys, the buyer, Wegmans, can disaggregate the data? Does it matter? If when they get the report, they can disaggregate based on information that they have?
Well, in this case, it does not matter because the prices purchased by Wegmans were economic data about mass-produced goods. When asked what specific information from retail data was of value to Wegmans, the store's pricing manager testified the pack, the price, the indicator. Now, pack, price, and indicator are identical for every similar item on the store's shelves, and I'll add back in their warehouse. So they're not individual in nature. I would urge the court to consult pages 562 to 646 of the record, which are an example of retail data's output. The sole content is generic economic data. Even if you disaggregate it to the point of saying 1 can of peas at this store costs this much, you're still talking about a can of peas that is duplicated numerous times on the shelf and in the warehouse. And Wegmans required that retail data check prices in multiple competing supermarket chains and multiple locations within each chain. So it was not looking for individual information.
So, and your time's almost up, if it's all right, the Chief Judge, listen, is it, however we rule, is it important for us to distinguish exemptions versus exclusions, or can we just assume here that this is an exclusion and that distinction actually exists?
We argue that there is no distinction between exemptions and exclusions. That's what the court held in
You're talking about Mobito? Is it
Mobile Oil.
Mobile oil, oh.
And if I may...
So
What about
if we-
Fairland?
I'm
What
sorry,
about
Judge, go
Fairland? I'm sorry.
Okay, well, Fairland Amusements concerned whether a general sales tax excluded certain sales simply because it didn't mention them. So the case didn't apply a broad statutory term to a particular set of facts, like in AT&T, like in Great Lakes, like in this case. There was no term to apply. Now, Mobile Oil itself involved an exclusion from the components of rent. And both of the cases cited in Mobile Oil also concerned exclusions. Young involved former tax law 386-G, which excluded items from allocated income, and Schwartzman involved former labor law 502(1), which stated that employment shall not include certain things. And in reality, they're the same thing. Exemptions and exclusions are both statutory
That's not
provisions.
the way that is, I agree with you, that's what Mobile Oil says. I think you're right. And they may have conflated those terms, and the question is, was that a mistake or not? But the way I understand the distinctions is an exemption you can't tax, but you could tax it. An exclusion is you can't tax it. It's not included in the income. And that distinction seems to be a pretty consistent distinction across states, in the second department, departments throughout the country. It seems to be a pretty common definition. And you're saying that New York has a special rule that conflates those two?
Well, let me go first to the first part of your question and register respectful disagreement. In our reply brief, we note that the federal circuits all say there is no difference between how you construe exemptions and exclusions. And As to the other states, appellee found respondent found 3 states, including one lower court from Pennsylvania. We found the highest court of 4 states. So if you're counting beans, we have one more bean than the other side.
And so if,
Thank you, counsel. Counsel?
Good afternoon, Your Honors. Jeffrey Harrod on behalf of respondents. Wegmans, may it please the court. Counting the beans.
Can we start right where he left off? You know, your position is that the mobile oil is explainable as a syntactical error. What's your basis for saying that?
My basis for that is, well, several, actually, Your Honor. To start off with, I respectfully disagree with my colleague. The cases cited by Mobile Oil dealt with exemptions, not exclusions. That's been understood in the 3rd Department and on down for 30 years.
Assuming for a moment that you're correct, if we look at whether they function in an equivalent manner, what difference does it make?
They do function in different manners, Your Honor. An exclusion, think of it, we'll take the example of a 1040, since that's something that I certainly can appreciate better. An exclusion is something that is not taxed ab initio, welfare payments, child support payments, that sort of thing. They're never taxed in the first place. Exemptions are things that fall within the tax bucket but then can be pulled out. Think of the personal exemption that we all have in our federal and state taxes.
For purposes of statutory construction, why should they be treated? I mean, I understand the definitional difference that you're giving me, but why would it matter for purposes of statutory construction as to who has the burden of proving its applicability? Why does that matter?
Well, because a base law, a rule of tax law is that the government can only take what the legislature authorizes it to take. In the case of an exclusion, the legislature says, you shall not tax that. In the case of an exemption, the legislature said, you can tax that unless you meet some criteria.
For example, in this case, they could have easily made this an exemption. I mean, the overarching definition of these transactions is so broad, it clearly encompasses this. And then they exempted it or they excluded it. What's the difference? It's just the language of the statute. It has no meaning other than that.
Well, I think, Your Honor, it does to the extent that there's an ambiguity that needs to be construed. If we're
Right, but that gets to how do we construe it. But I'm talking about what is the basis for treating them differently. Because in this, particularly this statute, this could easily have been an exemption. Your definition, overarching, very broad taxing authorities given by the legislature, and then they exclude it because they use the term exclude, but they could have just said it's exempted. What's the difference?
It was a decision made by the legislature, we presume understanding the difference between an exclusion and an exemption.
How long has this distinction been made in the 3rd Department, which is where the vast majority of these tax cases are heard?
I don't want to say forever, Your Honor, because that's imprecise, but a very, very long time.
But counsel,
issue.
it seems to me that what you are asking the court to do is to ignore its precedent and to recognize what is ostensibly an unworkable rule. Judge Garcia's already pointed out, you call it this, you call it that. At the end of the day, the only question is whether or not the person is going to pay that tax. Right? When we say that our law favors the government on the tax, that's once the legislature has decided to tax. There's no doubt here that the legislature has decided to tax. That is off the table now. And whether or not you call it an exemption or exclusion, it's just whether or not they're going to pay the tax.
Well, the distinction between exemptions and exclusions are well settled in New York and elsewhere.
Yeah, but you're inviting the next litigation, which is going to be, yes, we know the legislature called it that, but it really functions differently. And the court has now drawn this distinction and given it, rarefied it, and given it real meaning. And now we're going to be about the business of courts saying, well, this is really an exemption or this is really an exclusion, regardless of what the legislature calls it.
Well,
Go ahead, sorry.
I'm sorry, Your Honor.
No, answer.
Now, how do we
answer
avoid that?
Judge
Because that
Rivera's
strikes me as the problem that you're creating.
Well, I don't think, respectfully, Wegmans is creating any problem. I mean, the fact of the matter is that when the legislature adopts an exclusion, whether in name or in substance, it's making a decision that that particular service or good, as the case may be, there's something about it that you're not going to tax it in the first case. Whereas when you're talking about an exemption, it's something that would be taxed in the ordinary course, but there may be special circumstances, which is what...
Well, isn't it a policy choice? A legislature says they can tax all of my salary, but they make a policy choice. They say if you have a child, we give you an exemption, and we can't tax a certain portion of your child of your income because we do that. However, that's entirely different from an exclusion. An exclusion is income that I receive from somewhere that isn't taxable at all.
Yes, Your Honor, that's the policy. And I don't want to lose the fact that we are talking about sales tax here. So an exclusion versus an exemption, the question becomes whether the service provider is going to charge that sales tax in the first place.
Do we need to make that determination to decide the merits of this case?
You know, Your Honor-
Is that necessary for your argument?
I don't think that you do, and the reason I say that is while the Third Department did recite the rule, the balance of the judgment below doesn't indicate that Wegmans took any great benefit from the interpretive preference that we're now arguing for.
And in either case, Wegmans ultimately bears the burden of proving entitlement to the exception, correct?
Absolutely, Your Honor. The taxpayer always bears the burden. The distinction comes into play when we're talking about interpretation.
So,
I thought the burden shifted between, you can correct me if I'm wrong, between exemptions and exclusions.
The initial burden of proving entitlement to either always falls to the taxpayer, Your Honor. The burden differentiates depending on whether it's an exclusion or exemption when it comes to who gets the benefit of an ambiguity. In the case of an exclusion like this one, it's to be strictly construed in Wegmans' favor as the taxpayer, whereas if it was an exemption, it would fall to the
So
government.
if it's an exclusion, you benefit by it.
Yes, Your Honor.
All right.
so I want to go back to this idea of where this all comes from. Your adversary mentioned that it develops out of the New York City tax regs of 1956. And, I have to confess I wasn't around in 1956, but I'm wondering if there are any decisions interpreting the New York City tax regulations that we should be looking at.
Well, Your Honor, I wasn't around in 1956 either, so I'm with you on that one. But
It's a good year.
I was here. It was a good year that year, right? It was a great year.
I kind of walked into that one, didn't I? I'm sorry, Your Honor. We have looked high and low for any interpretive guidance, whether it be legislative history or judicial or administrative decisions, and I'm afraid we don't have that. We've had to really always go back to the legislative language to really make sense of this.
And I take it then your answer to my earlier question, the answer you just gave probably answers my earlier question, which is, at least as far as all the judicial decisions that I've looked at, I can't see one that points to something that I would say is an investigation of the legislature's intent in drafting these words.
No, Your Honor. We have documented in our brief some secondary sources, articles when they were contemporaneous with the adoption, but that's, these
But
are...
as far as judicial decisions go, no.
No, Your Honor. No, Your Honor. So that's why we encourage the court to look to the statutory language and specifically the word furnish. I'd like the chance to answer Judge Garcia's question that he began with, how do you determine what is individual? The statute directs us to the information service furnished to the taxpayer, not the raw data, but what is provided. And we've explained in our brief the multiple levels of how this entire service was from the get-go tailored to Wegmans' specific needs. It would only exist because of Wegmans' unique pricing strategy that was implemented. The data was collected only for Wegmans. It was put into a work component only for Wegmans. It was curated only for Wegmans.
So you want us to focus on the deliverable, I think is the term you use.
Yes, Your Honor. And I think you have to, because even in the Commissioner's own regulations...
So what exactly in the statute directs you to that definition?
The word furnishes. If the legislature wanted to exclude services that were created out of publicly available information, it certainly could have done so. I don't want to lose sight of the Commissioner's Regulation Number 4, which talks about a service that would collect newspaper articles. Public information, to be sure, and yet the Commissioner even concedes that could be personal or individual. The question is, what is being furnished? That is the question that must occupy the court.
Yeah, but it also says the services of collecting, compiling, analyzing. That's all the background work that goes into it, right?
Yes, Your Honor. So the question really is what...
So doesn't the section presume that you're going to take raw data and do something with it? Not always, not always.
Not always.
But it includes, that's why it's inclusive.
Yes, so the question is whether what you do with it is, I see my time has expired. May I answer? Thank you. The question is, what are you doing? And are you doing something that is designed for a specific taxpayer, one shot and that's it? Or is this something that can be for the benefit of several? That's why when you talk about the history of this statute or the predecessors of this statute, I can go back even further to 1931, and we're talking about reference manuals. On the shelf, predetermined, pre-collated information on a take-it-or-leave-it basis. What was done here was the creation of something wholly new.
So you're saying it's the output that's determinative, not the input?
Yes, Your Honor.
Thank you, counsel.
Thank you.
Counsel?
There is no difference between exemption and exclusion. Both
And
are...
so then how does the rule of lenity apply if that's true?
Well, you'll have to help me with the rule of lenity, but there is a provision, 1132C1 in the tax code, that establishes a presumption in favor of applying the sales tax. So when we apply 1132C1, which is cited in our briefs, you ask yourself, well, how should we look at this exclusion and apply it in order to promote the collection of the sales tax? It's a revenue-raising measure.
You read that as a presumption in favor of requiring the merchant to collect it, or actually a presumption in favor of its payment?
It is in favor of construing the statute so as to promote the collection of the tax.
Collection, though, meaning the physical act of collecting, because the sales tax has to be collected by somebody as opposed to who owes it.
Well, I think in the context used in that provision, it means getting.
Okay.
But the point I wanted to make is that both exemptions and exclusions are statutory provisions that narrow the tax base. You can't get around that. With respect to furnishing, the sales tax actually taxes furnishing. It taxes the furnishing of information. And it defines furnishing as including collecting, compiling, and analyzing the information. So if you say, well, Wegmans went out, Retail Data went out and specially collected data for Wegmans and specially compiled it into a database and specially sent it over to Wegmans in compliance with Wegmans instructions, well, that's taxable. And if you interpret what Wegmans did, the collecting, the compiling, the analyzing, as somehow bringing the exclusion into play, then you've defeated the application of the tax. You've made the statute self-defeating, and I would urge the court not to do that. With respect to the standard of review, when the commissioner, I want to...
Please continue.
I'll just finish this point. When the commissioner, we also cite another line of cases that say when the commissioner takes a broad statutory term, like personal or individual, and applies it to specific facts, the court need only decide whether the commissioner's decision is rational. That's AT&T, that's Great Lakes, that's Coal Industries. All of those are cited in our brief. I would urge reversal.
Thank you, counsel.